The legal information in this program is of a general nature and is not intended as specific advice. If you have a legal problem, contact a lawyer, community law centre or Citizens Advice Bureau.
Kia ora, I'm Catriona MacLennan. Welcome to the first episode of Know Your Rights, a new program about the law and how it affects New Zealanders. Each week we'll look at a different legal topic. We'll give you information about what to do if you have a legal problem. We'll give you 5 key tips about the law and tell you how to avoid problems. At the end of each program we'll answer your questions about the law. I'm a lawyer and journalist. Over the last 15 years, I've helped lots of people who had legal problems and found it hard to get legal help. I've twice worked in a community law centre. There we helped people who couldn't afford to pay lawyers. But it would be much better if people had information so they could avoid legal problems. If you know about the law, you know never to sign a paper if you don't understand it. If you sign the paper and then come to see me, it's too late. It's very hard for me to help you. Before you sign the paper, talk to your Citizens Advice Bureau, Community Law Centre or lawyer. We can explain it and then you can decide whether you want to sign it. This week we're looking at family law. The Family Court deals with about 67,000 new cases every year. If parents are separating and disagree about where the children should live, the Family Court will help you. If you're worried that your partner will take the children overseas without you knowing, you can go to the Family Court and ask for help. The Family Court also deals with divorce, family violence, children who've been abused and relationship property. It's a private court, so when you go there, it will be just you and your family in the courtroom. Later this year, the government is planning to make the biggest changes to the family court since it was first set up more than 30 years ago. So look out later in the year for new information. But now, to talk more about current family court procedures, let's welcome our 2 guests, family lawyers Hannah Ellis and Sal Timaloa. Kia ora, Hannah.
Kia ora, Catriona. I ngā mana, i ngā reo, i ngā raurangatirama, tēnā koutou. Ko Hannah Ellis taku ingoa, no ngā pohi rawa ko ngā tupu rawa hau. He roia au kia manakau. Kia ora.
Talofa, Sal.
Talofa lava, Catriona. E mo lava no o si atu bele vi inga whawhataile tu, ma whaatalofa atu, ma whawhailuai atu, wile pa ia malu lau whia. Ine wa mau se awa no whapenei, lo ingoa o sa whainga moilo awa timaloa o a fo se loa ia. Ine ngā lue ne o kilani o lo matata, ngā lue tūla whono whawhenga I a inga whanau po le family law barrister.
Hannah, can you tell people what to do if they're separating and need help to make arrangements for their children? How can the family court help them?
Well, the family court was set up to help people resolve their disputes about their children. And so they can do that by a number of ways. They can arrange counselling, and counselling helps parents talk about their children. It's not lie on the couch, tell us your life history stuff. It's about getting parents together to make a plan for the children. Mm-hmm. If that doesn't work, the family court can also refer people to mediation, and that's similar idea to, it's based on a similar idea to counselling, where people get together with a mediator, who's usually a lawyer, to help them again talk about the arrangements for the children. It's really focused on the planning ahead for the children. It's not about relationships or what people have or haven't done right in the past.
Sure. How many sessions of counselling would people have through the family court?
Well, at the moment, they can have up to 3 sessions with a counsellor. A counsellor is not a lawyer. They're trained specifically to help people try and reach agreement about the care arrangements for their children.
And if the parents do reach agreement either at counselling or mediation, that would be the end of the case, wouldn't it? The judge can make it up into a court order and that's all that people need to do.
Well, Yes, kind of. And counselling, a lot of people reach agreement and have a counsellor's report as the way that they record their plan for their children. Some people then go on to ask lawyers to put that together into a memorandum which is presented to the judge, and the judge makes orders if the judge believes those are best for the children. Similarly with the mediation, because a lot of people, or most people who go to mediation are represented by lawyers, they all get together, put their heads together, write out again a memorandum, everyone signs, and then that's sent to the family court for a judge to have a look over. And usually that can be the end of it.
So what happens if a case doesn't get sorted out at counselling or mediation? What's the next step that happens?
Well, the final step, or the last step for family court matters, is a hearing process. And a hearing process is when initially the parents have an opportunity to make those decisions. When it goes to hearing, the parents are actually giving that decision to be made by a judge.
Right, yep.
In the hearing process, and which is the last resort when the lawyers and the parties have exhausted all avenues of dispute resolution.
And that hearing's actually a formal court hearing like people see in courtrooms on TV, isn't it?
Exactly. It's a formal court process. It's with the judge, the lawyers and the parties, and there's evidence. For an example, all the affidavits, special reports, all assessed in the court, and the judge will make a decision at the end of the hearing as to what is in the best interest of the child or the children.
That's why it's so good if cases can actually get sorted out at counselling or mediation, because as you say, there it's the parents who make the decision, whereas if you go to a hearing, the judge is going to decide.
Exactly, and what the family court is trying to promote is for the parents to make such a decision, and if the case ends, it's also trying to promote for parents to ongoing to make those decisions for their children or their child without returning back to the family court.
What's an affidavit?
An affidavit is a sworn statement. It's a written sworn statement setting out all the facts of your case, and the affidavit becomes evidence in your case and is filed in the proceedings to the family court.
And who prepares the affidavit?
The affidavit should be prepared by the lawyer, and because the lawyer's role is to specialise in crafting the affidavit and setting out all the relevant information or the facts into the affidavit. But it doesn't mean that only the lawyers can prepare the affidavit. Even a lay person can also prepare an affidavit, but the difficulty with that is that the lay person may not have the specialist knowledge of the family court processes.
And if it does go to a hearing, does that mean that the parents have to give evidence in court?
Exactly. The parents or the parties of the proceedings will be provided to give evidence to the court. What usually happens when you go to the applicant is called first, the affidavit will be cautioned and presented as evidence to the judge, and then the opposing lawyer or the opposing party counsel will then ask questions or cross-examine the applicant and so forth to the respondents.
Right, yeah. And can you tell us what a parenting order is?
A parenting order is a formal agreement reached between the parties, or a parenting order can also be made by a decision in the judge in a hearing. And it actually states who of the party or the parent has the day-to-day care of the child and who has contact of the child. And the parenting order can be quite specific, as in exact telling what days and times the child should be in either parent's care, or it could be general. But they can also add conditions into the parenting order, but it's a formal court order.
There's been a lot of stuff in the media in the past couple of years saying that the family court spends a lot of time dealing with trivial cases about whether children should go overseas on holiday or things like that. Is that your experience? What cases does the family court spend most of its time dealing with?
The short answer to that question is probably no. I believe the family court deals with a lot of difficult cases, cases where it requires urgent attention, especially when it involves safety of children, or even safety of the parents or the parties, and that's in reflection either parenting, domestic violence, or even CIS matters.
Right, yeah. So a lot of the court's work is dealing with abused and neglected children and trying to sort out what's best for them.
The majority of the cases, but not all cases, but you also have to consider other matters, for an example, even just standard parenting or applications of just ordinary disputes between parents.
Sure. Hannah, what about grandparents? If they are not seeing their grandchildren, do they have any rights in law? Can the family court help them?
The family court, in short, can help them. The law that deals with the arrangements for children is called the Care of Children Act, and that allows for parents to apply for parenting orders, as Sarah's talked about today, but also talks about other people being able to apply to the court to have court orders made for them, for their contact with the child. So for a grandparent with their grandchildren, or for a parent or an uncle or aunt with a child. They've got to ask for permission, which is called leave, to ask for the court order. But it recognises that for a lot of children in this country, they're raised by grandparents, or grandparents have had a really huge role to play in their upbringing. So in short, yes, grandparents can apply to the family court to have court orders made for them to either raise a child, to have day-to-day care of a child, or for them to have contact with the child.
There's a very few cases, probably about only 5% in the family court, that are extremely difficult. How does the court deal with those cases?
The family court introduced a new process called the Early Intervention Program, and that was introduced in April 2010. And the purpose of that, when cases are filed, they're able to place them in the correct pathway. For all the urgent matters, they're usually filed under without notice, and those cases are dealt with, like for an example, domestic violence, or allegations of serious allegations of harm or violence against a child in proceedings. They will be placed on the Early Intervention Program on EIP Judicial Conference, and it'll be dealt with very quickly. Allocated a judicial conference within a couple of weeks from the filing of the proceedings.
That's to make sure that if adults or children are in danger, that the family court's trying to get to the cases quickly and help them, and they're not delayed in a backlog.
Exactly, exactly. The whole purpose is to make sure that that law for child is appointed to see that the child is safe. The judge had to look at the proceedings or the evidence before the court at the early stage, and making any interim orders necessary.
Hannah, can people get legal aid to go to the family court?
Some people can get legal aid. Legal aid is a scheme set up by the government to help people apply to the family court and to other courts for court orders, and it's to help pay for their legal fees. It's based on the nature of the case they want to take, and on their income. The most important thing is to talk to either their community law centre or their lawyer about legal aid. There's also a really good website, if they Google legal aid, that they can go and get some information about that. It's really important that people don't see it as a gift, because it's the government's money, it's taxpayer money. So if people's circumstances change while they're receiving legal aid, then obviously if they can pay it back, then they need to pay it back.
So people on a benefit, they would have a really good chance of being able to get legal aid. Yes. Some people who are working can, but you have to be earning a pretty low income, don't you? Yes,
you have to be earning a pretty low income, or they might ask for a contribution from people. But yes, if you're on a benefit, then usually, because you're going to be on a low income, then so long as you're wanting aid for something that they can help with, then you should be able to qualify. It's really important to talk to their lawyer about it.
And the lawyer basically, I was going to say helps fill out the form, but I think more or less the lawyer fills out the legal aid form. But people, especially people who are working, just need to know that they might actually have to pay some of it back.
Oh, absolutely. The forms, you can have a look on the website what the forms look like. The lawyer will ask, go through the forms with the client. They're not just making the information up. So they go through the information, and then the client checks it, and they'll get a copy of the application when the lawyer sends it into the legal aid people.
Can you tell us what guardianship is?
Guardianship, most parties get confused what parenting orders and guardianship, and they're two separate matters. Guardianship is the responsibility of a guardian to make big decisions in a child or children's lives. And matters related to guardianship involves education, travel, religion and health.
So it might be where the children are going to go to school, if they should have an operation, things like that.
Exactly. Exactly. Most guardianship disputes would involve mostly about education or even relocation. When one parent wants to relocate overseas, they have a responsibility to advise the other guardian. And if there is a dispute about that, then the family court is available to hear their dispute.
Okay. What happens if a man says that he's not the father of a child and the woman's saying that he is the father of a child?
Well, the family court can help there. Because it's really important for a child to know who their parents are. The law has recognised that, and a woman can apply to the family court for what's called a paternity order, and that's an order to name a particular person as the father. And that involves going to see a lawyer. Although a lot of people go to the family court and represent themselves, most paternity applications, in my experience, are done through a lawyer, and a lawyer helps prepare the paperwork to tell the court why she thinks that he's the father. That's then served on the father, and he has 21 days or longer if he's overseas to get back to the court if he doesn't agree. And if he says, look, there's no way that that child's mine, half the rugby team slept with her, then what is the usual process is that they arrange DNA testing. Legal aid is available if the person qualifies for it, and they can be approached to pay for half of the cost of the DNA test. And usually that's the end of the matter with the results coming in. Either the guy is or is not the father. If he's not the father, obviously the woman, pulls her application. And if he is the father, then either everyone agrees and they sign an agreement to say he is the father, and that's sent into the judge, or he kind of disappears and doesn't do anything, and then the woman with her lawyer goes to the court and has a short hearing in front of the judge, and the judge makes that order. On the flip side, if the father thinks he's the father and the mother says he's not, then he can also apply for a declaration that he's the father through the family court.
Who has to provide samples for the DNA testing?
Well, it's the mother, the child, and what they call the putative father, the father, the person that they think is the father. It's just a swab in the mouth with a long, I think this is the way they still go, with a long like earbud, and they swab the mouth, so it's not kind of, it used to be blood test, but nowadays it's just kind of a swab in the mouth.
Okay. Can you tell us about your role as lawyer for the children?
Well, the lawyer for child role was set up a number of years ago to allow children to have their say in decisions that affect them. So the role of lawyer for child is to do a number of things actually in practice, which includes seeing the child unless there are really special circumstances where they can't see the child, making sure that the correct evidence is in front of the court. There might be other specialist reports that the court might be helped by. It's to negotiate contact if that's not happening. Most importantly, it's to allow the child, if the child wants, an opportunity to share either their views, if it's a parent versus parent dispute, or if child death and family are involved, their wishes about what should happen for them. Some children don't want to have a say in what happens for them, but the lawyer's job is to talk through those things with the child to see if they want to have their wishes or their views known, and also to report back to the child about the outcome of the case.
So your role as lawyer for the child would be different if, say, you're appointed for a very young child compared to, say, if it was a 10-year-old or a 13-year-old. You just basically have to adapt to the situation.
Absolutely. I saw a 5-week-old baby yesterday whom I cuddled, which is great, but I can't really ask her what her wishes are for her future. And you know, the flip side of that is if I see a child who's 10, a 10-year-old's going to have a pretty good idea about what they think is important, what they would like to see happen. Doesn't mean that the child is in charge, because at the end of the day, initially it's the parents who have to make the right decision, or guardians, but if they can't make the decision, it's up to the judge to make the right decision for the child. But it's an opportunity for the child to be heard, and that's really important.
Right, yeah. Can you tell us what happens if one parent wants to take the children overseas and the other parent doesn't agree with that? How can the family court help?
Well, that's a guardianship dispute, so that parent needs to file an application to the family court and apply for that decision to be made by a judge. But if one parent takes the child overseas without the consent of the other parent, then that could be recognised as an abduction of the child overseas. And to assist that would be what we call the Hague Convention. And the Hague Convention is a treaty of all the countries who've signed this treaty to allow or help the country, the habitual country, to have the child return back into that country. And any family law issues, they need to be dealt with, should be dealt with at the habitual country or the residential country of that child.
Yeah, so if the children and the parents have been living in New Zealand, one parent takes the children to another country, the parent in New Zealand, as long as the Hague Convention applies, can have them brought back, because as you say, the law says that the issue should be dealt with in the country where the children and the parents were living up till now.
Exactly.
So the Hague Convention hasn't been signed by all countries, has it? What about how many Pacific Islands are in the Hague Convention?
I understand that there's only one Pacific nation that's signed under the Hague Convention, and that's Fiji. So such Pacific nations like, well, my country, Samoa, Tonga, they're not signed to the Pacific nations, to the Hague Convention. So that means that any parent who takes a child to Samoa, New Zealand courts can't make an order to have Samoa to return that child back into New Zealand.
Right, yeah.
But I also understand under the law that if the child is placed in a country for more than a year, then that country may be regarded as the new habitual country for that child. So the longer the parent leaves it and not applying to the Hague Convention or trying to get the child back, the more likely the child might be regarded as living now in the new country.
Right, yeah. So it would really depend on the situation, how much time's gone by. So if a parent does want to do something to get children brought back to New Zealand, they should really take action pretty quickly if they can?
Yes, exactly. Yeah. The longer they leave it, more likely that that child might be regarded or settled well, and all depending on the age as well of the child as well, when they obtain the child's views and so forth.
Thanks to my guests Hannah Ellis and Sao Timaloa. Here are the 5 key points you need to know about family law. You can get 3 hours free counselling at the family court for family problems.
Ka taia e koe te whiwhi kōrero tohu mō ngā haora e toru i te kōti a whānau, a kaore he otu.
Mo nise mana o mia se wheso swani e whaatalanoina mata upo whaafitauri te tonu mawhtanga o a inga mawhaau ngāli. O loo iei se wheso swani a le whalwha masinongo a inga e taua le counselling services. Tole tūla e fua ma le eise tongi. A whaaperitina ina o le counselling services e ala me le whalwha masinonga mo a inga po le family court.
A parenting order says how much time children will spend with each parent.
Mā te whakatau tia ki tamariki, e ki pēhea te roa o te noho e te tamaiti, i te taha o tāna pāpā, tāna māma hoki.
O le pepa e whaamaoni ai se whae unga e maua mai le whale whaamasinonga o ainga e tau le parenting order. E whalafola ato teime mā futai o alu whānau, ma lola ato mātua te tasi.
The judge will appoint a lawyer for your children in difficult cases. The court pays for the lawyer.
Mō ngā āhuatanga ua rawa, mā te kaiwhakawā tētahi roia e whakarite mō au tamariki, mā te koti te utu o taua roia e kawe.
E mawhai ona whaatonu le whaamasino, si loia e avea ma loia o alam whanau, mō mataupu whaingata ma whita. E te tongi e le whale whaamasinonga, po le family courts, le bilu loia, mō alo ma whanau.
The family court will make an urgent order if one parent tries to take the children overseas without telling the other parent.
Mēnā ka hakina e tētahi o ngā mātua ana tamariki ki tā wāhi me te kore whakaputa kōrero ki tērā atu mātua. Mā te kote a whānau tētahi whakahau e tuku.
E mawhai ana whaia se pepa wawe e le whaamasino o mātua. Ina wale whaamaunia ma wale ai se whasata inga le lei. Ma le isi o mātua e winga le awe o whānau I atunu I whafo. O le pepa wawe lea e whesa swani mo mātua e toi au maia whānau I New Zealand.
You can get legal aid to go to the family court.
Ka taia e koe te whiwhi āwhina a ture hei haere ki te kōti a whānau.
E iei awa noe mawhai on apalai se whesa swani meila mālo e te tongi eile pili lo ia e ala le whale whamsinonga I a inga e taua whaapea o le legal aid.
Now it's time for your questions. A viewer has asked, how long does it take to get a divorce? It's very easy to get a divorce. You don't even need a lawyer to do it. You can do it yourself so it doesn't cost so much. In law, divorce is called dissolution. To get a dissolution, you have to be separated from your wife or husband for 2 years. That's the only reason for getting a divorce. If you haven't been separated for 2 years, you can't get a divorce. You need to fill out papers and put them into the family court to get a divorce. You can download the papers from the family court website or else go into your family court and they'll give you the papers. The easiest way to fill out the forms is if you and your husband or wife do it together. Both of you need to sign the papers. It costs $211.50 to get a dissolution, and it's fair if each of you pays half the cost. Put the papers into the family court and it will do the rest. In most cases, you don't need to go to court. The court will process the papers and send you a letter in a few weeks telling you that the marriage has been dissolved. You can get married again, if you want to, as soon as you're divorced. If you're in a hurry to get a divorce, or if your husband or wife doesn't agree to the divorce, you'll need to go to court. And if you and your husband or wife own property together, you need to talk to a lawyer about dividing up the property. A lawyer has to sign some of the papers. Also, if you have children under 16, the court will want to know that you've sorted out who the children are going to live with. Look at the information on screen at the end of the program for more help. And remember, you can send in questions about any area of law to info@tritv.co.nz. Just put Know Your Rights in the subject line. All your queries will remain anonymous on screen, but we'll only respond if you do supply your name in your email. Thanks for watching, and do join me next week when we'll be talking about what happens when young people get into trouble with the law. We'll be joined by 2 lawyers who will explain what happens and how you can help your children. We'll also answer your questions. Ka kite anō.
The legal information in this program is of a general nature and is not intended as specific advice. If you have a legal problem, contact a lawyer, community law centre or Citizens Advice Bureau.